Just before we start, my thought was that we'll spend maybe 20 minutes, half an hour talking about the compact, but I wanted to leave half an hour at the end. Are any of you lawyers or law students? You are, okay, well you can help us. Why I'm asking that question is that for the next two courses, I wanted to spend a bit of time explaining to, to you a little bit of the legality behind what we'll be doing and the legal issues behind the cases, the comparative cases we're going to look at. So I'm going to go through a background to that, which I hope will help you to better understand it and not get lost. And Ando-san is here, might want to comment. She found some of the cases as well, has worked on it. So I didn't want you to just go fresh into tomorrow night and we start talking about cases that have been at the district and high court here, and with a group of about probably about 10 observers who will be lawyers, some of them who've appeared in these cases. So it may go off onto tangents, and I don't want you people to get lost in that situation because, well, I've tried to put the issues as simple as possible, but, and I'll mention it to you tomorrow, lawyers have a nice habit of following what I call the kick process instead of the kiss process. Do you know the difference? Well, the KISS process, appropriately named, is keep it simple, stupid. In other words, try and make your legalese and your legal stuff as clear as possible. And the kick one is keep it complex, kiddo, to put it in American terms. And guess where all the money's made? The more complex you make it, the more falls into the hands of the lawyers, and a lot of judges, and so they create what's called an aura of mystery, if you understand that, around their job, so they can get paid more, and the whole illusion, whereas, in fact, and I think I spoke about it last time we were here, good, top-rate lawyers will act like the Chief Justice did in the UK recently on that Brexit case, and put it in nice, simple, clear English. And I think that the Japanese judiciary might like to do that sometime in the future. It would assist them greatly. Anyway, coming to this, what we've done is I've sent this out to you, and rather than go through it, I just want to highlight a few things. But what I've done is highlighted the important bits in red, and there's quite a few of them. But this article, which was delivered, I think it took about an hour to deliver it in Wellington, so we're not going to run through it in detail. We've sent it out to you, but it is a very good positive commentary on it. Now, as an academic in this area, I think we should tell you that there are some negative commentaries. And one of them, I think, maybe Jeff Crisp on Saturday from the UNHCR will take at the conference here, isn't it? Yeah. May take a not such a positive view. And the learned James Hathaway has also written a fairly negative article. However, their views are that they actually want to go further than what the compacts are doing. In other words, to make them more binding and therefore be to upgrade the whole of the Refugee Convention and all forms of protection, which is fine and maybe laudatory aim to have as an academic, but I think Goodwin Gill is, in the real world, it's going to take one heck of a long time before people are going to sign up, particularly in a world of growing populism, is going to sign up to have more protection instruments with more teeth to them, as we say. So if you read through it, you'll see that he's he's put up some very good arguments as to why it's important. And he goes back, about refugee movements and the scope of them and the need for international cooperation. And he, as he said, he says that the principles and so forth, when it was set up, the 51 Convention was set up, left holes. We've spoken about the protection gaps here. And they needed a treaty, they needed something that clearly is within the principles of sovereign equality and non-intervention, which of course is the main message in Asia. And these principles are alive. So realistically, you're not going to get something that's completely concrete and will work. But 148 states were party, and I think it's gone up from there, hasn't it? I think it's probably about 160, I think it is 165. So yeah, we can see that, and he's given some history here, back in the 1920s, the tendency to refugees as someone benefiting from a status of protection, but only temporarily. And technically, in terms of the Refugee Convention, that's still the same sit. You're only bound to give surrogate protection for the period of time when the person is at risk of being persecuted, or real risk. When that goes away, then you can go through a formal process, hopefully, and bring in a thing called cessation. Most countries don't do that because it means that A, it's costly, and B, particularly if they've come from a long distance, then the resettlement of them back into their own country and the costs of doing it, plus the disruption to their family and everything else is enormous. And so particularly in island countries like New Zealand and Japan, the thought of not having a long-term resettlement is a bit silly, really. It just doesn't. Very few countries, they will have provisions in their law for cessation, but they actually never use them. Although we'll find out tomorrow that Japan looks as though it went down that stage, but the MOJ were just doing it off their own bat. They weren't bothering to give people the right to check it or to rehear their situation. And for that they got a rap over the knuckles from the High Court, which we will talk about tomorrow. Anyway, so but on the other hand, as he's saying, he's talking about close to 1 million Rohingyas. And again he gave the history of that, which was fascinating because I hadn't realised. I don't know what's happening here. Tiny little computer. And again, like a lot of the world's problem with refugees, they're caused by the British drawing lines on maps. And any of you who want to study that part of your history, and particularly in Europe, or in the rest, particularly if you're in Europe. Before I became a judge there, I was recommended by a very good Irish judge friend of mine to read 2 books, one about the Congress of Vienna and how after that Britain got itself, the whole of the Europe was chopped up and lines were drawn on maps. And then again, even more importantly, after the Treaty of Versailles. It is absolutely fascinating. And then you see the years down the track, the Iraq problems, the Iran problems, virtually all the Middle East problems were drawn up on maps by three guys, and even Wilson wasn't there most of the time. He was rushing back and forward to the US, and just done purely from their own off the bat personal interest. Half the time guys went to sleep, people didn't turn up, they were drunk. It's just horrible to think that's how the world ends up with these problems down the track. Anyway, this is the Rohingya one, which wasn't actually drawn by the British drawing on maps, but it's got a much longer history than that, but a very sad one. So, but when you see what's in the compact and how issues like the Bangladesh problem and massive movements across borders, that's really what the compact is about. It's not about really, 22 people coming here from Bangladesh now and claiming refugee status. It's really more to deal with mass immigration, and hence the same thing as I said in New Zealand. You're probably never going to get affected by it. Maybe it would deal with the would help the Australians with boat people, but even there the numbers are not significant for this type of thing. So it's idea of translating the reality of the compact, the aspirations of the into reality is really what's behind it. So I think that he set out the detail of how it was done, how it operates, the difficulty in getting undertakings. Well, it's all just sort of real world stuff that I think, and it fostering cooperation. And the main thing really is these 23 objectives that are set out in it. And if countries work towards those and they can measure that over time, then, as you see, alternatives to detention, non-discrimination, facilitating remittances, access to basic services, these are all the reality of refugee movement. And so it's good to see that they're given prominence and that they will allow it to use. So, as he says, the lack of apparent accountability provisions is where it's being criticised. And for those that want to cherry pick, in other words, pick the best parts and not the worst parts, it's got problems. But basically, it's better, certainly something that's far better to have than not to have. And it also highlights the problem, like the UNHCR's problem of an $8 billion budget, which they probably need more than that, and only 55% of it pay the bill. So you can see why the UNHCR struggles to keep up. And even here you notice that there used to be, when I first came here 20 years ago, a lot more people, students working there and others working there on part-time, so forth, to do the work, was now, and the office seems to get smaller, and the number of people like mine and so forth, just their workload is exponential. Okay, so that I won't go through the thing in detail, but as its goals, improve burden sharing, which we spoke about before, strengthening natural protection responses, national protection ones, enhanced socio-economic conditions for refugees and communities, and greater efforts to resolve, protect it. So it's not just about protecting the people here, but it's trying to resolve the problems, as Mai was talking, for like the statelessness before they take place. Okay, I don't think I'll take you through it in so much detail because it's hard to read probably anyway, so that... Are there any questions you want to raise on it? I'll just leave you to read through it actually, because it's pointless me going through it, because he says it far more eloquently than I did and expresses it in that way. So that's, it's not too long, and I hope you find it a useful article to go through. Okay, is there any questions on that compact or on the migration compact? Yep. It's a very good question, and the answer is yes and no. In other words, it's a human right to have the ability to seek asylum. All right, that's in the UDHR and it's in the ICCPR. It's a clearly established human right at a high level of right as well, that you can seek asylum. Okay, and so having got to that stage, then you have a refugee convention which sets it out, which is more and more part of international law, and with, as I'll talk about a bit more tomorrow, with a very high level of compulsiveness, so that it's almost black letter law, but it's not yet. It's customary international law, and it's customary international law because of its level of adoption throughout the world. All right? And that has grown exponentially, literally, over the last 30 years, particularly in the last 20 years. And, well, I'll go through it now because I'll do it twice, but you can have it. Up until about 1980, most of the refugee situations were people escaping from the Iron Curtain. And so countries like the States and so forth brought in provisions, their own domestic provisions of the Refugee Convention, and anybody who managed to get away from behind the Iron Curtain was automatically a refugee. And virtually they didn't have to prove anything, apart from it was accepted that past persecution equalled future persecution because of the whole country environment they came from. As the whole Soviet Union broke down, then there was the explosion in people going around the world, plus aeroplanes and travel getting cheaper and all those things, all happening at the same time in the late 80s. And that led to a growing demand by countries, firstly, to bring in to regulate and do their own refugee determination centres as well as their own migration laws. Many countries had very little in the way of both migration law or refugee law in the 1980s. When I started, and one of the reasons I got into this business was being asked by our government, because I was silly enough to write a letter to the Minister of Immigration on migration matters and said, where's the regulatory and legislative background for all these, for all the granting of migration and so forth that you're giving to people? And at that stage there was a business migration program and so forth being started. Where's the regulatory basis to it? Where's the legality? In other words, if you want to appeal against it or you want to bring judicial review of a decision made by officers around the world, how do you do it? And as my reward from that, the Minister of Immigration, who I'd known through my business career, said, right, you can be the private sector representative on a total review of our migration and refugee policies that we're undertaking. And so I was able to join about 18 and 19 public servants from every department you can think of, and as the only private sector representative for about 6 months while we tried to do that. And the result of that was to bring in legislation, a regulatory, next step down, statutory regulations to provide for all policies, a business migration policy, a points policy, all sorts of spouse policy and all sorts, which was called GRP, government residence policy, a whole set which had legal base to it and was all set up that way. And so, and a little while after that, the same thing was done for refugees. So, but that was common. So it's a fairly new item, and that's why the law is new in this area as well. Yes, there was. The Refugee Convention was in 1951 to deal with the legality, again, by states in Europe after the breakdown of Germany and everything else there. And there were literally millions of people displaced, and they were drawing new lines for them to get behind and which country was going to be part of which. And of course, as you know, the Soviet Union decided it would divide Germany in two and Berlin in four and all the rest of it. And as a result of that, all these countries were trying to find a legal way, as I've said all along with the New Zealand Act, keep it legal, to deal with these people. And that's what, coupled with the whole human rights environment from the UDHR, brought the Refugee Convention into law as a personal right. See, prior to that, refugee status had been given, going back to you might have heard of the Nansen passports, and Nansen, who was the Norwegian guy who actually was the first refugee, League of Nations guy who looked after refugees, but that was done on a group by group. In other words, for example, Assyrian Christians. I don't know if you know the history of Assyrian Christians, but they were diabolically treated by the Turks, the famous Kemal Ataturk, who got so cross with them that he thought he would solve their problem by hanging one on every lamppost between, this literally happened, between Istanbul and Ankara, which, as you know, is one heck of a long way. And so he virtually was genocide. And so that sort of thing was what they were trying to deal with. So Assyrian Christians were put in that category, coming out of Lebanon and so forth, because white Russians, the same sort of thing after the Bolshevik Revolution. They were groups of people. So you can be a refugee because you came from that. In other words, it wasn't an individual right. It was just the International Refugee, what was it called? International Refugee Commissioner or something, I forget his title exactly, said these are them and let's look after them. They then worked with countries to send them around the world to give them protection. In fact, funnily enough, in New Zealand, a lot of Assyrian Christians came that way in the 30s to New Zealand. And so and then couple that with all the problems, particularly the Jews had out of Germany during the 30s and during the war, that's what led to the UDHR and making these things an individual human right to seek, Article 14, to seek asylum. So that's it. And what I'm saying is, in the past 30 years, particularly last 25, there have been this huge explosion in law by the highest courts. Unfortunately, the only thing they didn't do in the Refugee Convention, as has happened with the human rights thing, is there's no sort of ultimate world body or world court to appeal to. It's technically possible for one country to take another country to the Hague Court, but it's never happened, and why would it? But so there's no way of taking a case from here, for example, and complaining to Geneva or somewhere that bring some sort of case that they're breaching the terms of it, because there's no provision in it to do that. And so that's why it's meant that the jurisprudence, or the soft law or customary law, has come through from regional courts, particularly in Europe, like the Strasbourg Court, the European Court of Human Rights, which covers not just the EU, but 50-something countries, from Russia right across to Iceland, are all covered, and they all sign up for that convention. So cases there deal with these types of issues, and therefore there's a lot of law coming into it. The same thing happens with the CJEU, the Luxembourg Court, for the whole of the EU. In the Americas, the Inter-American Court deals with these issues at quite a regional level, and again in Africa. The courts in Kenya and so forth deal with these things on an Africa-wide basis. So it's only really Asia-Pacific that's sort of missed out at the regional level. But then, in addition to that, some of the best courts in the world, who have a long reputation of writing good law, have built their case load as well. So you started with the Canadians and the Americans, and right across Europe, the British courts at the highest level started writing good jurisprudence on this, late 80s, early 90s. The Irish courts, Swedish courts, and so this happened, and the Conseil d'État in France, Netherlands, and in Belgium. And as I say, the Germans didn't, because they took this, and in the early days, a lot of people got refugee status in Germany through a sort of domestic route under their constitution, which allowed refugee status under their constitution. Anyway, I won't go into all the detail of that sort of thing. But so that's how it grew, and then tribunals, judicial tribunals, as we have quasi like in New Zealand, started writing the law on it. And so you had this huge explosion, Australia, all around the world, South Africa, setting up this high-level courts writing a lot of jurisprudence. So when you add all that, and then you add on to the top of it a list of academics, which is longer than both arms, you know, the Hathaways, the Goodwin Gills, the Anchors, the Spickerborgs, there's a whole, I've mentioned them tomorrow, about 20, there's about 50 of them now. There's now a group in Australia, McAdam, Foster, there's a whole growing list of them. And they're growing in this part of the world as well. People like Arakoki Sensei and have built up and written books on it, even here. So that all builds towards giving you a situation of customary international law. And so to say, as is often said here actually, both at the academic level and particularly at the court level, there's no international standards. I'm sorry, that's just absolute rubbish. There is, and they are strongly now in virtually every country in Europe, Africa and the Americas, and perhaps not in the Middle East. And to a degree in India, they are recognised, although they have their own situations. They are not that far from the international conventions. And so it's you know, the countries who are not are really the countries who haven't signed, like the Middle East, Singapore and so forth. So that's why I say it's a very strong customary law, and because it is, it assists. If you're writing something that's reasonably consistent, and even in Europe they're getting more and more consistent, then you get the respect both ways, because every migration situation is two sides. You know, there's the country of origin or the country of nationality and the country you're going to. And if you're going to send people back, the more respectable, the better your determination system, the better the chance it'll be, and the better your human rights record is, the more receptive they will, not just to refugee things, but to everything. To signing, you know, free trade agreements. Why was New Zealand the first place that China signed a free trade agreement with? It wasn't just because they liked our kiwi fruit, which we'd stolen from them some years before, called Chinese gooseberries. It was because New Zealand had a very high reputation for upholding the rule of law. They mightn't do the same there, but that's, you know, for little countries, it's highly, highly important that you do that. All right, does that explain a bit about it becoming virtually a human right, although not, but certainly the right to seek is, but not the full weight of the Refugee Convention is just high-level customary international law is probably the best way of putting it. Any other questions on that point? I'm good. I'm pleased we started on that because we'll just go on for a little while. When we come tomorrow to go through these cases, there's one or two things I want to explain to you as non-lawyers, so you don't get lost. The first thing is that we're looking mainly at court. We're looking at court cases from here and from Korea, and comparing them with a lot of that international refugee law I was just talking about. And the thing is that if you go to court, there's basically three approaches. In other words, you're going to go from a government decision on whether the person should be recognised, all right? And that has been left in the convention as to how you do that, not what you do or what the law is, because that's in the convention. In other words, the legality of the convention is in the convention. Otherwise, why would you sign it? The whole thing, it's got in there who's a refugee, what rights they have, you know, the obligation not to send them back, the obligation not to stop them coming across the border, Article 31 when they don't have regular papers. These things are all legal requirements when you sign up. how you go about the process of confirming or recognising them, not creating their status, confirming a status they already have, is up to each state to do. All right? So that's the bottom line with it. Then if you want to appeal that decision, then internationally there's sort of three ways of doing that. Okay? You're with me so far? Nobody lost? The first one is what's called pure JR, pure judicial review. And what happens then is you go to a court and you say there are manifest or clear, strong errors of law in the decision of the first instance decision maker. All right? And the first one, of course, they've actually got to write a recent decision to give to you. Otherwise, prima facie, they haven't done that, so how can they, under any rule of fairness, say that theirs is a valid decision? So in other words, you're appealing purely on a point of law, and then when it gets to the court, the lawyers would argue that there are errors of law in that decision, and therefore it has to be remitted back to do it again, and the court will give directions on how you do it right. Okay? And that's how a lot of the law has been written around the world. So that's the pure judicial review approach. Now, there's not a rehearing of the case, it's just, is there any error of law? And there's no error of law, then that's the end of it. The first primary decision is upheld, first instance decision we often call it. Okay, so that's system one. The second system is a total, what we call de novo, completely fresh look at the claim at the time of the appeal tribunal or real appeal court's situation, because refugee law is about looking forward, we discussed in the previous course. It's prospective. In other words, is there a real chance of being persecuted, not persecution in a generalised term, if this guy is returned tomorrow? And that's so you've got to have a crystal ball and look into the future and come to that decision objectively on all the facts, etc. So that's really what it's about. So in that situation, you then have a second hearing, as I say, after the first one. That's called a de novo, fresh hearing, and you can take into account, that tribunal, the evidence that was before the state, before the immigration department or wherever it is, but it's not binding. So it's a completely fresh decision, because if it was a year since the previous one, clearly that others from both parties' point of view may be out of date. Things may have got wonderful back in where you came from, or they may have got much better. You've got to do it at the date of hearing. Okay, so that's the second alternative. And then beyond that, like that's the New Zealand option, you can then go to the court on an error of law. In other words, you've got two bites. You can go to the courts on a pure error of law basis as well. There's then a third combination, which is a mixture of both. In other words, you go to the court and you have to find, firstly, there are material errors of law, and then if there is, then that court has an obligation to go on and try and fix the problem if they can. And that's the way the UK, the court I was on, that's what we did there. We did both. You find the error of law, then you go on and try and determine the case if you can. And that can be done often if it's just a legal error. If, however, it's a credibility error, or a poor interviewing error, or a procedural error, or a interpretation error, or something like that, then clearly as the person's not there, and you can't interview them and give them the right to be heard, in other words, hear the other side, which is the most basic thing in law, in dealing with evidence. And so you can't do that, so you have to send it back to the prior instance, to the earlier one, and give them directions on what is the correct way of assessing credibility or so forth, which is the reason why I gave you that paper before, the structured approach to refugee decision making, judicial guidance. That's what that was written for. And because it's got in that all the problems you can have with credibility, and there's about 50 or 60 of them, and that if you get some of those wrong, then it needs to be done again. On occasion, you can, even at the higher level court, particularly if you want to write a country guidance or a precedent type decision, you can call the people to give evidence and hopefully get good lawyers and all the rest of it and write a serious case which may then be used, and this is more in the common law situation, to give you a precedent that everybody else has to follow afterwards. So then there may be 3,000, I think I mentioned, 3,000 Sri Lankan cases waiting behind it, waiting for your decision to give them guidance for the future. So these are just shortcuts. Anyway, so there's those three systems. And outside of Japan, I don't know any country that doesn't do it that way. The Philippines, we just discussed yesterday, is trying to decide which way it should do those things. But as there's not that many, there's only five countries around Asia that are parties to the convention, I think. So, and Cambodia I don't think does anything. China doesn't do anything. So it's really here in the Philippines and Korea, possibly in Hong Kong, but there's a backward way of getting there in Hong Kong, which we won't go into. But anyway, but what happens in Japan appears to be, and that's what we're going to discuss, is that when people appeal from an immigration department decision, or what do they call them now, refugee, they've changed their name, refugee assessment officers or something. There's a new name for they're not called the IB any longer. Council, is it? Yeah, it's not. They used to be called the Immigration Bureau. They've now got refugee.
You mean the
within the immigration department?
Yeah. That's now upgraded for this is agency.
Yeah.
This is immigration services agency.
That's it. Yeah. Within the Refugee Services Agency. Anyway, so if you want to appeal against their decision, I don't know what the translation is in Japanese, but a lot of people say it's judicial review. Well, it's not judicial review in the sense that I described to you, error of law, because none of those decisions talk about, they don't even, where there is a decision that from either from the immigration people themselves or the refugee examination counsellors. I don't know whether there are decisions or what there are. You simply can't tell from the court decision if they never talk about an error of law. So clearly it's not, in an international sense, judicial review. It is an appeal, but what they do is they look back at the decision at the time when it was made by the immigration people or the RECs, and somehow retrospectively reassess the case as if it was the time when it was made by the immigration officer. When refugee status is declaratory and is made at the time looking forward, that ain't going to work. And so, in my view, as I said earlier on, you're starting in the wrong place. That's what you do in an immigration case. In an immigration situation, each country, sovereign country, has the right to make its own immigration laws. And so, when I came here, I got a professor's visa. If I breached that or overstayed it, then quite rightly, they could say, we're going to set you out, kick you out. I could perhaps appeal, but what they would do is go back and look at the law that applied when I came in here and what I'd done right or wrong. And that's quite right, because they created a status for me when I came here, all right, or before I came here. And so what I had to do was meet the requirements, and Professor Sato has brought me the end of my contract as well, signed by the president of this university, and that meant I could fulfill the status, domestic immigration status, and it was created for me when I got here and ticked all the boxes. With refugees, you already have that status, or are presumed to have it, when you cross the border, as you saw my do figuratively earlier on, into this country. All right? And all that's happening is we're now going to confirm whether, in terms of Article 1A2 or all of 1A, whether you are a refugee, in other words, a person who has a well-founded fear of being persecuted, etc. That's what's happening. So the only way you can check that is, one, find their errors in the first one, tell them to do it again, or B, do it all again with new evidence, forward-looking evidence, COI particularly, as of now. What is the value of looking back, and many of these cases go back 7, 8, 9, 10 years, 2011, 2014, 2016, they're making a decision that's purely historic, and it, with the greatest respect, is valueless because it doesn't tell you today whether the person's a refugee or not. And the reason they evidently give for that is because they want domestic administrative law to apply to it. Well, you can't have it both ways. Why, in Japan, if that's the case, do you not return everybody who applies for refugee status immediately? They don't. They're not sent back because it's presumed, as asylum seekers, they potentially are refugees, and you would breach Article 33 of the Convention by sending them back. So, hello, we've got one part of the system saying we're not going to return you, and we've got the other part of the system that when it appeals it, and a lot of the time the courts will actually grant refugee status, but that's done on evidence that's 3, 4, 5, 10 years old. Anyway, to me, there's a mismatch. So that's why I explained it to you, because that's what we'll be talking about. And there's one case that may show the light, a Sri Lankan case, which our learned lady here brought to our attention under some. And it looks as though, for the first time, maybe by accident, but that the court, the High Court too, not just the District Court, is saying, yes, it's declaratory, and no, the Ministry of the MOJ cannot write its own rules on what's legal because they've already got the status and all you're doing is confirming it. So it'll be an interesting couple of days. Any questions or anything else? Or are you all totally lost?
Yeah, maybe a little bit difficult, the students who have not studied the law. So next 2 days, I think focusing on the more case studies, especially the real precedent judgment, which is actually translated by some volunteers, including some thanks to you, and then this is quite efforts. So that is a really highlight of this course. So in this sense, many practitioners also participate to discuss it. The main sort of issues of the difficulties, as he described, is Japanese system is not fitting in good for the implement, I think, refugee determination under the convention. That is my view. As he mentioned, the authority of determination belongs to the Minister of Justice. The court can just listen to the challenge against this decision. And if the court, this is abusive, it's totally wrong finding, something like that. The court has authority to reverse, just rescind, setting aside, but not such a final authority to decide who is a refugee or not. So even if the court just reversed the decision made by the Minister of Justice, this authority is sent back to minister, and the minister will again review it, and sometimes even they didn't follow the court decision because they said the Minister of Justice has an exclusive authority to determination of refugee status. The court, of course, will intervene, but under the law. The law is, as he said, the especially act for the litigation against the administrative decision. General, it's not only the refugee determination. Anything, for the tax agencies or any authorities, public office will decide against you. In such case, you just complain to the court. If court agree with you, just rescind. But still, the authority, the determination authorities, these ministers. So in this discrepancies as a problem. That's why it takes a long time. After the determination by minister, the court will intervene. But that's only the examining past of the decision, which is actually already outdated. So in this sense, that is difficulties, I think. Anyway, we should discuss these issues case by case tomorrow and the day after tomorrow. So if you have already some materials, maybe I will upload for all the student review beforehand to understand some roughly.
We've sent them out to you. Unfortunately, you will find in the Japanese the language is quite complex. And I'm sorry, I can't do anything about it. And so the translation into English is equally complex. And I've had to read some of these decisions 6-7 times in the English version to get a grasp of what's happening. And so they've got a tendency to talk about the disposition for the denial of the rejection of a grant of refugee status. And you think, and there's about not just double negatives, but you sort of get into about 4 negatives, which is very hard to understand. Anyway, we're trying to unscramble that. And please, the first thing I want to say exactly what Sato Sensei is saying. This is purely an academic exercise. Make sure it's on there. It is not a legal exercise because the translations are just done kindly by people trying to assist, law students and others. Some are very good at it and some are learning. And it is purely for this academic exercise. And really the only question I'm asking, or we're asking really, as academics, not as judges, really, is there any help that's out there in international law land that might be able to help Japan in the future to find its way to have a more productive system that works in everybody's interest, claimants, Justice Department, taxpayers, so that the whole thing is beneficial. And it runs more smoothly, and examples like the New Zealand one, even the British ones, improve vastly, that work and do the whole job much more quickly using international law will help you. And so that's really what the challenge is. And some of these decisions go beyond where the courts are now saying more than what Sato Sensei has happened in the past. In other words, the courts are not now saying, so I'll put it the other way. The courts are actually saying, we're granting refugee status and you're bound by it, Minister of Justice. That's what they literally say that in one of these cases. So that's why, as we say, the sands of time are moving. And so there may be here an opportunity to use existing law that's now at a high level in Japan that can move things on. And maybe a newer generation of judges who are actually trained in international law and so forth will start to see this. And to me, and that's why I'm pleased that Sato Sensei has quite visionary in this and getting people to think about these things academically in the future. And I think a lot more, I've noticed this time particularly, a lot more academics are really starting to give an academic path which will assist towards a better understanding and a better result for everybody. And that's really, so it's a purely academic exercise. If you're a law student, sorry, this is not a legal exercise. You have to go one hell of a lot further than that. We'd have to get official translations. We'd have to go through the whole thing before learned papers could be written. Maybe our lawyer, Sujin, maybe think it's a good PhD challenge for her or something or other. But it's certainly, this is purely an academic exercise, and it may help with NGOs as well, to saying, you know, there's a few basics here that don't add up.
Yeah, of course, this is a purely academic activities, but yeah, we already always doing some kind of critique of the judgment of the president,
yeah.
Because we are free world, so any criticism is okay. And, but the point is just for comparative study to understand what are the issues, you know. How the Japanese system practice in comparison with New Zealand practice or British or Koreans and so on. Because we are on the same board and we are under the same convention. Why we are so differently applied, differently interpreted? That is the issue. Okay? So let me just advertise last class. This is, as I mentioned, a bit irregular. Last class as a seminar open to the public. The academic conference, side event for the academic conference of the Japan Association of Human Security Studies and Japan Society International Development. This both academic association jointly have a conference 2 days, 16th and 17th this weekend in this campus, Kumaba, from the morning to the evening. Then at the last, this class will be held as she just showed. The main theme of this academic conference is refugees/migrants and education and employment or works. That is the most crucial issues we face in the globalization. And today we discuss a little bit global compact, on refugees also, and regarding migrant things, this adopted last December in the United Nations. So, well, this compact, the demand or request, not only the state, but also the non-state actors, such as the university, or business sector, private sector, and NGOs, of course, to be responsible for the refugee protection. So this is a sort of a new paradigm. Refugee Convention as a hard law bind the state, but non-state are free, basically. Basically, the international law just bind the state because this is law of nations binding the states. But this global compact is also along the same line of the 2000's global compact. The address more or less non-state actors. So it says also the whole society approach. It's not just judges, not just administrative justice, not only the UNHCR. Because the situation of the refugees, migrants, out of of all these state actors. There's so many problems, so many peoples suffering. So in this sense, I would like to discuss how the university-specific or student academia to consider this new paradigm. Maybe some scholars are very criticizing this compact destroys the conventional regime because not hard law, this soft law. Soft law is no binding. You're free to no need to bind, no sanctions against violation, but just a recommendation. But at the same time, this addressed directly to the non-state actors, as I mentioned. So in this sense, we have to consider what we do, what we should do, not just criticizing authorities, government or international organizations. This is our responsibility to share. So in this sense, how this refugee determination system, a lot of problem, a lot of outdated because of the now globalization is very extreme now, more huge problems all over the world. So in such a situation, this messy situation, how we will work together. So that is all the background of this conference. Then I suppose this seminar, we discuss this kind of specific point, the modern age, contemporary age or future. What is the international refugee law will be developed. Even if not only the hard law, but as the soft law, I think. Yeah, exactly. Soft law is, I think, key for the future.
For the non-state actors, and I agree with you. And
yeah. So in such a way, your participation is quite encouraged, not only the lawyers, the judges of this narrow mandate, more or less, we will be responsible as the citizens of this global society. So that is a point. And also, I will let you know that this refugee cafe is also a very specific side event. Afternoon of the 17th. Actually, this is organized by students. And so around 10 or 20 students, mostly the undergraduate student will take initiative. And coffee is free.
Coffee is free.
Provided by some companies. So each table, some refugees from the different countries will speak with you. So you just come and sit together to drink a coffee. And if you don't want to drink a coffee, maybe we can provide some other tea or something like that. Anything. So just be frank discussions, a dialogue, and they'll be happy to be friends with you. Because in Japan, it's not so many refugees so far in comparison with other advanced countries. I think that is why we are not so very much aware of the situations. And so in this sense, we should learn from these refugees or migrants or asylum seekers. Asylum seeker is also very much a concern in the people in transition. The reason why this global compact also migration is also come together as a twin, I think, because more serious problem is the people in transition to the other country, this exploitation of human trafficking. This is also related to the root causes of the refugees. And refugees itself is also very much transforming, not just days of the 1951, the Cold War and Cold War time. Our world is more complex, complicated. So in this sense, comprehensive protection, not only the refugees under the convention, some other people who just not be covered by the convention must be also highlighted for the human security point of view. So in such a way, we are thinking of the future, well, more positive future. So please come back next. Tomorrow we will have Martin. Tomorrow?
Yes,
Yeah.
yes,
Okay.
yes. He should have just arrived, actually.
Yeah, she just arrived. So the Martin is also a very interesting New Zealand QE judge. She
Yeah, yeah.
very charming
Yes.
and very
And he's
much.
still a judge. I'm a worn-out judge. He's far more up to date. And
Yeah. So please enjoy it. Okay. Any other thing to discuss?
yeah, well, Hague Convention cases, for example, children's cases, it certainly doesn't happen in very many fields because it's international law applied domestically. But cases such as under what we called Hague Convention cases on the rights of children are in a similar situation because you're looking forward to see what will happen to this child in the future under the provisions of the international provisions of the Hague and the CRC, the Convention on the Rights of the Child. So that's probably the best example, but there are very few. But the fact that judges may not be doing it on an everyday basis doesn't mean it's right. It means that somebody has slipped up along the line and not recognised this is a piece of international law. And we talked last time, I went through and gave you about 11 or 12 differences, and really you have to ask why pretty well every other country in the world does it forward-looking, because unless you grasp that, you're actually not starting in the right place. And so I know international law is not taught here. The other, on Saturday, Sensei and I gave an address to the International Law Association at Hongo of the professors in there. There wasn't a great number there, but they said, and these are the teachers at Hongo, here's the most reputable university in the country, saying people just don't study international law here because they don't think it's that relevant, or they can't find. But on the other hand, they're now establishing a court specially to do copyright and intellectual property cases, because they're governed by international law. So again, why would you do that? And the people, and some of these, and some of the professors suggested that they should bring, if it's difficult for judges to do it in this area here, because they are so confined to keeping it within domestic law, then you may need a special tribunal of the same nature as they're setting up for the intellectual property and copyright situations. So the examples are there and they're coming, and I think that's what, and for example, that's exactly what happens in many countries, certainly in New Zealand, Ireland, Belgium, a whole lot of countries, is they have a specialist tribunal. So you set up what's called quasi-judicial fact-finding, as well as making legal decisions to deal with those, and the Canadians have now brought in the same thing. So that's the way you do it. It all depends in the end whether you want an answer, and a good international answer, or whether you don't. It's not my call. If Japan wants to suffer on and pay huge amounts of money that create abuse, or can create the abuse, because the abuse comes in because if you have that several years, then that's just a big sign to the people traders and smugglers, hey, let's go to Japan, we can work even illegally for 6, 7, 8, there's one case there, 20 years the guy's been here. And, you know, it's, as we say, I don't know if you know the Dickens, but Bleak House. It's Bleak House Revisited, the famous case that Dickens went on for 20 years. But it's the same sort of thing. And so that's, and that was interesting I was unaware, but the international law professors were telling me that these little bits of positivity are there. And as I say, this one case, one or two cases here where there's a little bit of a light down the end of the tunnel, as we might say. And to me, that's a good opportunity for NGOs and for academics to say, hey, there's a bit of light there. Even if we can encourage, it's in the end, the decision is political. Let's be honest about it. That's the bottom line. And so if you can encourage politicians to say, look, we can do this a lot cheaper, a lot more effectively, and everybody wins, not just one or the other, and the efficiency and the cost goes down, then let's try and do it. And so it's a very, what you say is a very good question, and it was interesting to see these learned professors at Hongo immediately saw, even though they're not familiar with this field, immediately saw the comparative. And I must admit that was the best part of my time there, to see that there is something positive. You know, it's always where the money is, but in trying to protect intellectual property and copyrights for Japan. So why not protect properly your borders and your refugee obligations in the same way? Any other questions or queries before we close? Okay,
so see you tomorrow.
Okay,
Yep.
Thank you very much, and thank you for excellent questions. They're very good.